Executive Director, CEO of the Kentucky League of Cities. I have Brianna Carroll, our Director of Governmental Affairs, with us to do a legislative update for you all, the city managers and administrators group. We're a little bit sad that we're not able to get out and do our normal updates and around the state, but we did want to share with you, so you did have some information about the laws that were passed during the last session, and that way you could get going on implementing a lot of them. We had I'm going to have to try to figure out this screen sharing thing again, and I'm going to try to do it. Brianna, have to tell me whether I did it the right way. Did I do it the right way?
Yes.
All right. We had a pretty good legislative session. If you all want to type questions in the legislation and or in the question and answer section, you can do that, and we'll be happy to answer questions as we go along. The 2020 legislative session, I would put ourselves up against any other association. We had 10 of our initiatives that the board voted on that ultimately became law. So that's a pretty good track record. In addition to our initiatives, the board voted, and Tim and others, Nate, that serve on the board of directors will tell you we debate every bill, and a lot of bills are introduced that weren't initiatives, but that our board voted to support, and 41% of those bills actually made it through. And this year, our board had voted to oppose 28 pieces of legislation, and all of those were defeated. We were able to kill any of the bills that we opposed. The effective date on legislation is 90 days after the conclusion of the session. This year, that'll be July 15th, unless there's an emergency clause on the legislation, and the emergency clause means it'll become effective on the signature of the governor, or in a couple of instances, when the General Assembly overrides the veto of the governor, if it had an emergency clause. We'll get right into the legislation that passed. The first bill was House Bill 44. That was a piece of legislation that I'm still learning how to work this stuff, that deals with key infrastructure assets. It expands a bill that we championed probably 2 years ago in the 2018 legislative session, dealing with trespass and use of drones on utility property and other key critical assets and infrastructure owned by a city. It adds natural gas pipelines and related facilities to the definition. Before that was excluded, and creates a crime of trespass upon key infrastructure assets if you physically enter the property, an individual does, or uses a drone to observe, take pictures, or fly over the property. It also expands the crime of criminal mischief in the first degree to include tampering with key infrastructure assets in a manner that renders the operations harmful or dangerous to the public. And a new provision in the law would authorize a civil action to be filed against any person that knowingly directs or causes a person to tamper with key infrastructure assets, and allows, in addition to that, in that civil action, the recover of attorney's fees and court costs, and can result in punitive damages if that standard is met. House Bill 204 is another expansion on legislation that we helped from a couple of years ago. Representative Savannah Maddox introduced that bill. It prohibits registered sex offenders from living within 1,000 feet or being on the premises of a leased playground. The legislation before, we had no prohibitions on registered sex offenders on public playgrounds before. That bill passed in 2008, but there were several playgrounds that fell into this leased category, and this expanded that definition, and so we supported that bill. Brianna, why don't you talk a little bit about our fun with 911 this session?
This session, we had a couple of bills related to 911 and funding and for the next generation 911. House Bill 229 replaces the telecommunications reimbursement program or component of the CMRS fund to instead provide that the 2.5% allocation shall be used solely to establish and maintain the statewide next generation 911 initiatives. Those that will also modernize the definition of the prepaid wireless telecommunication service to also encompass devices or services paid for in advance that have unlimited time for a predetermined period. So that's for the next generation 911. We passed, as you all remember, legislation a couple years ago related to the board and ensuring that the Lifeline providers or the Lifeline phones would also participate in or would also pay for the CMRS fee. There were definitely some issues this session with those providers, and so what we ended up passing was House Bill 208, which addressed the loophole created by federal legislation in 2018 that banned wireless providers from paying the 70 cents per month service fee to those Lifeline users. This would make sure that we were able to restore the $1 million per year for our local 911 centers. And also we were able to get an emergency clause on that bill. So it became effective March 27th.
House Bill 362, there was a lot of discussion about expansion of broadband into our rural areas. That's even become more important. But House Bill 362 by Philip Pratt, who's a legislator from Georgetown, created a new broadband deployment fund, a matching grant program for both governmental agencies and private providers that would be housed in the Kentucky Infrastructure Authority to be eligible to apply. The grant applicants in the matching component of it have to pay 50% of the project cost, exclusive of any other supplemental grant funding that the community or the private provider may receive from the state or federal government. The projects, in order to qualify, have to most effectively provide broadband to the greatest number of underserved or unserved Kentuckians to get the highest priority in terms of being able to access the funding out of there. We had some issues with the bill when it first started because the language looked like it allowed access to the water and wastewater funds. We wanted to be sure that the legislation did not do that. And we got a provision added that absolutely prohibits the commingling of funds in the infrastructure revolving loan fund and the broadband deployment fund have to be separate within KIA. Additional requirements will be coming from KIA about access to this program. They'll have to promulgate some regulations and how to challenge grant applications and deal with those. So the rest of the mechanics of the way this is going to work are yet to be developed because it used broad regulatory language. The big kicker on this is that the General Assembly only passed a one-year budget. They did not do a biennial budget this session. And so as a result, they did not put any money in the broadband deployment fund. So that's that may be something they address next session. So it's there, but no monies will come out of it. House Bill 375 is one in a long battle we seem to have with the previous gubernatorial administration about executive orders. 375 redoes an executive order that was enacted by the previous gubernatorial administration dealing with the Kentucky Fire Commission. And in this case, it reorganizes the Fire Commission to allow the governor to appoint, but allows us as the League of Cities to submit 3 names for service on there. Before, the governor could pick any mayor. We wanted to add any mayor or other city official who would be able to be appointed and serve on that from from a city that maintains a regular fire department or a Chapter 95 fire department. The legislation also went a little further to require that the commission be composed of both females, have gender, and also protect racial minorities. It also tries to get geographical balance by prohibiting any more than 3 commission members from residing in the same congressional district. So that will ensure spread out among all the congressional districts. It ensures that firefighters and representatives are nominated by the Fire Association. Those nominees have to be experienced firefighters. We had an issue with before individuals being appointed that had no background or knowledge in firefighter service. And instead of requiring a meeting 6 times a year, it reduces that to say that they have to meet 4 times per year, and allows 6 members or allows 5 members to call a special meeting, which is less than a quorum. Given their difficulties with getting meetings together before, that's why they wanted to include those provisions. House Bill 378 is one you all probably like. That's really turned into an initiative for us as we went through the legislative process. In the 2019 session, a bill was passed that raised the filing fees for city governments up to $46 for each local government lien file, your code enforcement liens. That made it through on the last day of the session on a consent calendar in the House. And in fact, the House members were so upset about that, they took away the consent calendar at the start of the session. So we got this tacked on to another bill to get that fee back down to just a flat $20 fee for any local government lien filing, no matter what. No additional fees, no storage fees or things like that are added. So Representative Walker Thomas from Hopkinsville got that passed for us this session. It seems like something with golf carts comes up about every session, and this was no exception. Representative Santoro from Boone County introduced House Bill 382, and this is a simple change to the golf cart ordinance. It simply permits golf carts to operate between sunset and sunrise, so when it's dark outside. Before, the state law prohibited, even if you adopted a local ordinance, for golf carts to operate on any public highway when it was dark between sunset and sunrise. You had to operate between sunrise and sunset. This would allow them to operate. Now, most of you that have golf cart ordinances probably mimicked the state legislation that has existed prior to 382. And so if you want nighttime operation of golf carts in your community, you'll probably need to amend your ordinance, because your ordinance prevails. Home rule controls in this case. And so you may want to address your ordinance in that instance. Brianna, are you watching for questions? Anybody got any questions? I can't see. Why don't you take over HCR 5?
HCR 5 is just a resolution that requests the FDA and the National Institute on Drug Abuse and the DEA to expedite the research on the safety and effectiveness of the use of marijuana for certain health purposes, to assist Kentucky's lawmakers in developing the policies that are evidence-based and scientifically sound around medical marijuana.
And this is short of obviously the passage of the major medical marijuana bill that made it through the House. Our board voted to support this to get additional study from the federal government. Our board ultimately ended up endorsing the medical marijuana bill, which was a little surprising.
Senate Bill 56 raises the minimum age for the sale of and purchase of tobacco products and vapor products from 18 to 21.
You want to do 195?
You want me to?
Go ahead.
House Bill 195 enacts permanent language to authorize that a city or city agency that is located within a county containing a population of 80,000 or more to elect to post the legal advertisements on a notice website. Sometimes this is a little confusing, and cities think that they have to be 80,000 or more of their population. It's just a city located within a county, 80,000 or more. If the city elects to use the alternative advertisement, then they must do a one-time newspaper advertisement informing the public of the alternative posting. There are some requirements that JD has pulled up on this slide. So the advertisement shall be no more than 6 column inches, shall be published within 10 days of the website posting if it is to inform the public of a completed act, or within the 3 days of the website posting if it is to inform the public of the right to take action. Must include the subject matter of the posting, include a telephone number and mailing address or a web address where the city may be contacted so that the public may inspect or obtain the copies of the full document. Also, we must provide a full URL of the website, of the notice address where the full advertisement can be directly viewed. Any failure to advertise shall not be void, or shall not void the action or negate the enforceability of the matter posted. However, the violation or failure to publish the newspaper advertisement subjects the officer responsible to a civil fine of not less than $50 and no more than $500, along with those attorney fees. The contents of that website must meet the requirements that would be applicable if the city had used the full website and the publication. Obviously, we've received some dismay from certain cities that were not included in this. This is part of a negotiation and a compromise that we were able to reach. So JD can talk about that at the end too. The alternative website shall occur within the time periods required by KRS Chapter 424, and the posting shall be maintained on that website until the deadline passes or the event that you are advertising passes, at least 90 days if the posting is to inform the public of an action taken, such as the enactment of an ordinance, and also for 1 year or until it is updated or replaced with a more recent version if the substance of the posting deals with the financial status of the local government. So that would be your audits or your budgets. The alternative posting must be displayed prominently on the homepage or the first page of the website in a manner where the public can easily identify and access the advertisement. A city using this alternative method must include a statement on the website that individuals who have technical difficulties may contact the city for information on additional ways to access that document, and include the telephone number for the city so they may contact them. Proof of publication is required to capture the posting and store it electronically or in the paper format, and the clerk shall complete an affidavit for each posting stating compliance, including the dates of the posting, the specific statutory requirements being satisfied by the posting, and the URL. This evidence must be maintained for 3 years and shall constitute evidence for compliance. JD, are we drafting an example of this?
Yeah, there's an affidavit available. The legal department's going to put that out for your sample affidavit for your proof of publication. The statute says too that you have to maintain it for 3 years. We would recommend that you maintain it indefinitely in case there's some challenge to the ordinance down the road. But at a minimum, you have to keep it 3 years. But the legal department, this will go into effect July 15th. Will be sure everybody and your clerks especially have access to a sample affidavit if you're one of the cities that qualify.
House Bill 351 was also passed, which was, but House Bill 195 was the standalone bill, and 351 was the revenue bill, which we had included, the House included our language in. That bill also included language that said you are required, they are required, the newspapers, to issue the following statement with this advertisement was paid for by, insert the name of the governmental body, using taxpayer dollars in the amount of, insert the amount paid for the advertisement. House Bill 195 also includes an additional provision that applies to all of the cities, providing that if a newspaper makes an error or otherwise fails in time or substance to make a publication after receiving the required information to publish, that the city can remedy the error by using the alternative website posting provisions.
So that provision would apply to all cities, not over 80,000. So if you're sitting in Paris, Darren Jordan just asked a question, and because the newspaper either lost it, missed the deadline, and you got them, and it's no fault of the cities, got them all the information, you could remedy that by using this statutory scheme, even if you're a city that's under 80,000, or a city in a county under 80,000 and not otherwise qualified. You could use it to make up. That way the newspaper doesn't control the legislative process.
And it's not based upon the population criteria, because there was a question asked about this in the chat. It's not based on the city's population, but the county's population. So if your city is within a county of a population of 80,000 or more. And
so
we will continue to work on, obviously one of our core principles is equality and making sure that every city has the same opportunities, and as the larger, the small, and we want to make sure that everyone has the same opportunities, same tools. And so even though this is only for cities within counties of 80,000 or more of population, we will continue to press for equal treatment for all cities, including for next session.
So this impacts about 152 cities. Of course, 83 of them are in Jefferson County, which is one that qualifies. Throughout the state, I think it's about 10 counties. Hardin, Madison is added, Kenton, Boone, and Campbell are all included. You've had that ability for the past 2 years. Just to give you more history, because we did take a lot of flack on reaching a compromise. Our first principle is do no harm, and we know we had several cities, 148 of them, in fact, including many of you from Northern Kentucky, that had this advantage for the past 2 years, and it would have expired. The House has been very supportive on at least doing this. They put language for everybody in the revenue bill that was again amended in the Senate, like it was 2 years ago, to put the population criteria back in. And then I think this helps us get a lot closer, Darren, to your point. We put all these provisions in the statute, and now all we need to do is a simple strike through with regard to being limited to counties under 80,000. So I assume the board of directors will continue to vote because it's composed of a lot of cities that don't have this advantage for us to continue to do this next legislative session. So a lot of talk about House Bill 415. This is a direct shipment of alcohol bill. It passed during the session. The governor did not sign this when it became law without the governor's signature, but it does create a new state, not a local, but a new state license called a direct shipper license that can be obtained by producers, manufacturers only, not Amazon or internet retailers, that they could obtain an additional license if they manufacture it here in Kentucky, or if the manufacturer or producer is located in another state. A vineyard, a winery from California, for example, or if you want to get your bourbon from Texas, they'll be able to directly ship those alcoholic beverages into the state to legal age consumers in Kentucky. That's bypassing the three-tier system, the retailers who obviously had a problem with it, and the distributors also had a problem with it. The license will limit the monthly amount any single producer, if they obtain the license, could ship to a consumer, to an individual consumer, depending on the type of alcohol. So you can't order cases and cases and cases of yourself of a particular distilled spirit or malt beverage, but it applies to wineries, malt beverages, and distilled spirits. The law, our board had some issues with the original concept on this and wanted to ensure that, and the retailers as well, wanted to ensure that the shippers or the producers had to pay all applicable state taxes and local taxes. A lot of communities have a local alcohol regulatory fee. In that case, it requires that the shipper pay the applicable regulatory fee if it's imposed at the delivery point. So if you live in Elizabethtown, for example, you have an alcohol regulatory fee, you do in Elizabethtown, you do in Danville, the shipper will have to collect and remit the fee to Danville, not at the point of sale. And in order to facilitate that, this is going to work very similar to the way the insurance premium tax statutes work. We're going to have to give a little, and that means we're going to have to start filing our ordinances so that the Department of ABC can create a list so these people that get shipper license will know who has a license and what that license fee amount is, so that they can collect that and remit it to the appropriate jurisdiction. So once this gets going, after August 1st, if you amend your alcohol regulatory ordinance, you have to file the amended ordinance. There's no timeline requirement like with the insurance premium tax ordinances that you have to do 100 days prior to the start of the fiscal year. This is any time it's amended. It kind of works in conjunction with the current alcohol regulatory fee laws in that you are supposed to adopt your alcohol regulatory fee each year based on what you spent in the previous fiscal year. And so pretty much you're going to be doing this, any amendments to alcohol regulatory fee are going to generally occur around the start of the fiscal year, around July 1 anyway. In addition, Mike Gunn is asking if we have an ABC, if we have an ordinance in place that makes no changes, do we need to file it with ABC to be on this list? So you got to do the initial filing, Mike, by August 1st of your ordinance so they can create the list. If you don't make any changes thereafter, you wouldn't have to update it every year. But you will have to, in order to comply, even if they have it, you need to refile it again and be sure to denote with ABC that you're filing it again to conform with the requirements of House Bill 415. Every session, it seems like they run an alcohol cleanup bill. Senate Bill 99 made it through this session. It expands the ability to conduct local option elections. It now allows a microbrewery, a local option election for microbreweries if it's located in a dry or moist city or county, to have a special election for it to do sales. And if it is, they would get an NQ4 and a non-quota retail malt beverage package license if it is ultimately approved by the voters. It also did away with the sunset on local option distillery elections that was set to expire. This removes that sunset and continues without a definite end date to allow local option elections in dry or moist territories for distillery sales. It amends the law prohibiting sales at a licensed small farm winery before 1 o'clock. Current law prohibited the sale at small farm wineries before 1 o'clock on Sundays, and this removes that state law prohibition on that. permits a holder of a retail package license to hold an MQ3 retail drink license as well, and permits persons under the age of 21 to be on premises where alcoholic beverages are sold if the premises, their customary business is live music or other entertainment, in order to have people under 21 on the premises. So that's changing that state law.
House Bill 8 establishes a Medicaid ambulance service provider assessment to assist the ground ambulance service providers with a disproportionate number of transports billed for payment by the state Medicaid program. Upon notice of approval for the federal matching funds, the proceeds are to be used to increase the rates paid by a managed care organization for the emergency ambulance providers services and paid as a supplemental payments to the ground ambulance providers in a proportional amount according to the number of the Medicaid ambulance transports. House Bill 351, we were able to add some language from a bill that was not, due to timing of the session, going to receive final passage. And so we were able to add some language into this bill to increase the permissible term for an ambulance service contract between a local government and a private provider from 1 year to 4 years.
Called this a Nate Pagan bill. I don't know if Nate's on here or not, but he had this put on the agenda, and we were able to get it through.
And that was a bill that did have an emergency clause, so it became effective April 15th, that language. House Bill 357 provides reciprocity for any member of the U.S. military or any person in a contiguous state who is certified or licensed and in good standing under the National Registry and in their state as a medical responder, emergency medical responder, an EMT, an advanced EMT, or a paramedic at the same certification or licensure level in Kentucky. This is our first step at trying to help all of our cities that are having a difficult time with the applicant pools, and especially those that are on the borders of other states.
I know Mike Gunn's on here. He brought the issue on the border states to our attention as well. House Bill 298 is the police pursuit legislation that had a lot of attention this session. Mainly because we had in 3 consecutive days, 3 consecutive losses of life due to police pursuits here in Kentucky. One of the legislators that lost a constituent called and was going to introduce legislation that allowed the state to take over the policies to engage in police pursuits, and we were able to explain our general opposition to the state getting into a policy or procedure making process with regard to the operation of police departments. What we were able to do, though, is work with him, and their board actually ended up liking the bill once we got through with it and said, you know what, everybody should have a policy in place. We're all right with that mandate to deal with police pursuits, but the legislature shouldn't specify what policy should be observed because it changes. So what this does is require every law enforcement department, law enforcement agencies to adopt, implement, and to begin enforcement of written policies that establish standards, procedures, and guidelines before January 1 of this year. Most cities are already compliant, and most, but certainly not all, sheriff's departments are already compliant with this. And it's to deal with both when to begin and when to stop vehicular police pursuits. The policies are required to address subject areas. It's supposed to define what a pursuit would be, what would constitute a pursuit. It's to set out decision-making criteria to assist officers, your officers, in determining when to initiate or when to terminate a pursuit. It also, the policy has to enumerate responsibilities of pursuing officers and the tactics that they can use during the pursuit. It's also required to address coordination and communication with supervisory control where it's available. It doesn't normal practice says you get somebody that's not engaged in the pursuit to also advise the pursuing officer. If that's available, that command staff, that's supposed to be addressed in the policy. It is also supposed to establish a process for reporting and evaluating the pursuit after each pursuit, after one has concluded. Once you have got that policy in place, the law enforcement agency has to obtain a written certification from each officer that he or she has received the policy and instruction or training specific to that policy. As you all know, officers move jurisdictions, and a jurisdictional policy may be different. And in this case, this ensures that each officer gets that information about what's applicable within their jurisdiction on the policy. Now, this should be a pretty easy task for most everybody. The League of Cities, along with the Association of Counties, the Sheriff's Association, the Police Chiefs Association, the Department of Criminal Justice Training, and even the FOP have a model policy committee, and the model policy put out by that group already comports with the requirements, and most cities have adopted that or something substantially similar to it. Copies of the policies have to be filed with the Justice and Public Safety Cabinet, and they need to be looked at annually. You can revise them anytime, but if you update them, then you need to file the updated copy with the cabinet as well. We wanted language in there about liability because, from our perspective, this creates a big liability or loss situation for our cities. We wanted to be sure that the trial attorneys didn't sink their claws into it and say that the statute itself created some kind of standard of conduct that could be used in litigation against the city. And so the law explicitly provides that the requirement to have a policy isn't to be construed as to mandate actions in an individual situation, or that it's preemptive for additional policy requirements, home rule is preserved, or create that additional civil liability in that instance. The law 298 also requires all POP certified officers to complete 4 additional hours of emergency vehicle operation training at least every 2 years as part of their 40-hour in-service requirement. This is not an additional requirement, but we're saying, look, this is where we're losing officers' lives or other people's lives. Let's make this a part of the curriculum in in-service training so people actually get informed on how to do this properly. So it's not an additional mandate, but your officers are going to have to do that every 2 years as part of their in-service training. And then it has an enhanced penalty provision beginning on July 1st, 2020. The law is going to require the revocation of a license of any operator who ultimately is convicted of fleeing or evading the police in the second degree. So that is I don't think there's any questions on that. If there's not, we'll turn it over to the superstar who finally freed CERS.
Well, House Bill 484 is our free CERS bill. As all of you know, we have been on this road for many years and drafted a compromise approach from the full separation. Since 2018, we've been following the working group, the legislative working group that's been studying the administration of Kentucky retirement systems. And so we were able to actually receive final passage of House Bill 484, which establishes the County Employees Retirement Systems Board of Trustees. So the Kentucky Retirement Systems Board of Trustees will remain. We are essentially just removing our CERS representatives off of this board. They will continue to have oversight of the Kentucky Employee Retirement Systems, as well as the state police retirement systems. The CERS and KRS boards will work within one administrative structure that will be named the Kentucky Public Pensions Authority. Our CERS Board of Trustees will consist of 3 elected representatives. 2 of those will have a majority of time from the non-hazardous system, and 1 of those will have a majority of time from the hazardous system. 2 will be appointed members from a list provided to the governor by the Kentucky League of Cities. 2 will be appointed members from a list provided to the governor by the Kentucky Association of Counties, and 2 will be appointed members from a list provided to the governor by the Kentucky School Boards Association. The KRS Board of Trustees will consist of 3 elected representatives, 1 from SPRS and 2 from KERS, and then 6 will be appointed by the governor. 4 of the KRS board members and 4 of the CERS board members will come together to form the KPPA, and that board will review the administrative and personnel and issues and expenses. Each board will handle the investment decisions, the auditing, asset allocations, and medical and other professional or technical services. The KPPA will also provide the benefit counseling, administration, the information technology, the legal services. They will complete and compile the financial data and reports, and they will also hire 1 actuary for the boards. That was a compromise that we made toward the end of session, as many legislators want to move toward 1 actuary, and we felt that because this new structure of the joint authority, we would have a 50-50 representation, that we would have more decision making on that actuary. The governor is prohibited from abolishing or reorganizing any board and from replacing any board member. We also added language that no municipality can file bankruptcy if it is in default or delinquent in the payment of pension contributions. Coupled with 484, we recognized that we needed to address the rate issue and also the fact that we knew budgets were going to be tough this year, and we were able to work with Senator McDaniel on freezing the CERS employer contribution rates. And so in Senate Bill 249, you'll find that those CERS rates have been frozen from July 1, 2020 to June 30th, 2021 at the current 24.06% for non-hazardous employees and 39.58% for the hazardous duty employees. And it will require that these rates are the rates that will be used for any future adjustments. It also clarifies that the percent payroll method for the amortization will be used, and resets that the amortization period beginning at with the 2019 actuarial valuation will be reset for a period of 30 years. It requires that an increase or a decrease in the unfunded liability caused by legislative changes, assumption changes, or any gains or losses after the 2019 valuation shall be amortized over a close 20-year period. So that should help with some smoothing effect. The next slide shows the CERS non-hazardous employer contribution rates from 2020 to 2030. And these are the rates with the changes enacted in Senate Bill 249, along with what these rates would have been without it. And then the next slide will show the CERS hazardous employer contribution rates from 2020 to 2030 and what those rates are with the changes enacted in Senate Bill 249 and what they would have been without this bill. And I want to thank all of you for helping us push this initiative on 484, as well as being able to pass the rate relief in 249. You guys have been wonderful in engaging your members in your cities, so we really appreciate that.
So hopefully this is a start of the freeze. We won the battle on transitioning over, at least at this point, to the level dollar amortization using the percent of payroll that was embodied in 249. This will flatten the rates, at least for next fiscal year, but that'll give our board, the CERS board, a chance to get in, look at it, actually use data, and not be influenced by political philosophy in setting assumption rates. And then the smooth in requirements in 249 is another big deal, which is something we advocated for on July 12th, 2017, with the board to actually smooth in actuarial assumption changes, and 249 will mandate that they do that, since they refused to listen to us then. House Bill 570 amends the Interlocal Cooperation Agreement Act, and it modernizes it to give some greater flexibility to local governments to combine services and functions. This piece of legislation was out of a study group appointed by the Speaker of the House that was composed of the local government chairman and the House and the House Appropriation and Revenue chairman, along with KLC Keiko and the Pegasus Institute, all worked together to develop some recommendations about modernizing Kentucky's tax code, things that needed to be changed to create additional efficiencies or additional revenue. One of the recommendations that came out of that was this bill to ease the bureaucratic process for entering into agreements, whether they be mutual aids or creating other interlocal agencies to share services of that type. That was in addition to, obviously, the recommendation that did not make it, which was the constitutional amendment, which we'll talk a little bit about at the end, to amend the Constitution to allow different revenue options for cities. But this bill did make it, and it's largely a cleanup bill. It hadn't been amended since 1962. The act hadn't. It requires agencies that are created by cities and counties to have some deference to their city or county by requiring them to get approval before they establish their interlocal agreements. It expands the number of entities that are authorized to enter into interlocal agreements. So if you're wanting to create an interlocal agreement with a special taxing district or another SPGE, for example, you would be able to do that. And interlocal agencies themselves would be able to enter into their own interlocal agreements. And that's why we put that trigger on there, that any agency that you create has to report that back and get the authorization of their establishing entities. It clarifies the power of an interlocal agency. There was some lack of clarity around that. If an interlocal agreement did create a separate board or commission, referred to as interlocal agency, it ensures that it has the power to perform the purposes of the interlocal agreement. One theme that runs through the whole bill is that the contracting parties, the city and county, the parent organizations here, have ultimate control of what powers are given to an agency if it's created, by virtue of putting that in a constitutional type of document like the interlocal agreement itself. It streamlines the process for filing amendments. If you're simply adding or taking away parties to the agreement, you just have to file an update with the Secretary of State. You don't have to go to DLG or the Attorney General's office or the county clerk's office. Either the party that's added or deleted would file that with the Secretary of State, or if you have an interlocal agency in your interlocal agreement, they could file that on your behalf. So multiple filings are eliminated. And my favorite part of the bill is it removes a requirement for filing the agreements with individual county clerks. That had become a cumbersome, complicated process. The current law said your interlocal agreement couldn't go into effect until your clerk accepted it, charged you some money for filing it. This just takes county clerks out of the entire equation. Before, we had to wait for 60 days to get approval. The law required, if you did an interlocal agreement that involved a state agency or any party other than a city or county, the Attorney General had to review the contract or the agreement as to form to ensure that it met with the statute, that it had all the provisions that the statute requires. This it was allowed them to take 60 days to do that. Likewise, if it was just between cities and counties, cities and cities, or counties and cities, it had to go to the Department for Local Government. They had 60 days to review it as to form as well. This shortens that from 60 days to 30 days, and it adds an additional provision that says once an agreement is approved by DLG through that process, that in that instance, the contract or the interlocal agreement's no longer subject to being challenged as to the validity of its formation. Now, substantively, it could still be challenged, but in terms of challenging whether it was validly formed in compliance with the statute that governs the formation of interlocal agreements, this would be conclusive once DLG approves it. If the DLG or the Attorney General's office fail to do it in time, within the 30-day period, it's deemed automatically approved. Now, that existed in current law, so they have the 30 days to do it, or it's going to be automatically go into effect. And we wanted to also ensure, as we were making this modernization move, to ensure that no existing interlocal agreement was disrupted, and this ensures that this non-codified language, that it does not impact any existing interlocal agreement or invalidate it that existed on the effective date of the act. Senate Bill 5, special purpose governmental entities. This is about the fourth run on this bill. It finally made it through. The governor vetoed it, but the legislature overrode this veto along with House Bill 195, which Brianna talked about with newspaper publications. We got that was the first bill the new governor vetoed, and the first bill that the General Assembly overrode the veto on. They overrode the veto on this one as well. We were neutral on this bill. Senator Alvarado from Winchester fixed it for us when he first introduced it 4 years ago. But and it's important that it contains some of the provisions that we had put in there, and it really doesn't change much of the law related to us in dealing with the special purpose governmental entities that we create. It requires any special purpose governmental entity besides air boards, Chapter 75 fire protection districts, and ambulance service districts. Those are all taxing authorities that impose a tax to submit any increase in the tax to the city or county that created the agency. As you all know, counties are mainly the ones that create taxing entities, but there are a few exceptions out there. It maintains a current exemption for reporting. This is the provisions that Senator Alvarado put in for us, dealing with other SPGEs like our utilities, our tourism boards, housing authorities, and other things that cities create. We did not want them running back every time they're going to adjust these types of fees. And so it excludes, for non-taxing items and just fees, any rental fees. So if your Parks Commission's renting a gazebo or picnic shelters and are changing that fee, they don't have to come back to the city to get approval. Fees established by any kind of contractual agreement, any kind of admission fees that are charged by the SPGE does not have to. They're exempt. Fees or charges to recover costs incurred for connection, restoration, relocation, or discontinuation of any service requested by any person. The utilities like that, any penalty, interest, sanction, or other fee imposed by SPGE for a failure to pay a fee or charge. So those are generally your utility late fees, which the governor has suspended right now in his executive order. Amounts that would be charged to customers or contractual partners for non-essential services provided on a voluntary basis. Fees or charges authorized under the federal law that pursuant to federal law may not be regulated by the Commonwealth, and these apply to a lot of the TVA utility rates or fees that they impose if you're a TVA utility. Purchase water or sewage treatment adjustments made by an SPGE is a direct result of a rate increase by its wholesale water supplier or wholesale sewage treatment provider. And any new fee or increase for which the SPGE has to go to the PSC for approval. Any other charges or fees imposed by a special purpose governmental entity for the provision of any service that's available on the open market. This is a really broad exception, which probably captures everything that was mentioned, or most everything that was mentioned before, and then a specific exemption for municipal utilities for the provision of power, water, wastewater, if the statute or an ordinance already requires its submission in that process, if you have a local ordinance or statute that requires approval. We had language added that Alvarado added, I guess 4 years ago, that says that this law cannot be interpreted to prevent a city or county from establishing more stringent requirements. Again, this concept of you as the creator, the city government as the creator, should be able to control the agencies that it creates. Senator Alvarado and Representative Bart Rowland did us another favor before the session ended related to or dealing with COVID. And this is the COVID bill. It has an emergency provision in it. It became effective when the governor signed it on March 30th. We had asked the governor for some of these things in an executive order. They were a little slower at doing it. And surprisingly, in this case, the legislature acted more quickly to get us some of the relief that we were hearing from cities early on when the pandemic started. It is a temporary measure. Senate Bill 150 overall has a lot of different provisions in it, but it was enacted for the purpose of assisting Kentucky in its response to the pandemic. It deals with some business operational components, some healthcare provider provisions, and then we got some things in we'll talk about here applicable to local governments. First thing it did was permit a license holder for alcohol by the drink to serve alcohol beverages in a covered sealed container and by the package, by delivery, or on a takeout basis in conjunction with the purchase of a meal. So a lot of your restaurants that are doing curbside or deliveries are taking advantage of that with their margaritas and other types of drinks like that. It also addressed an issue we heard from your Municipal Clerks Association members, or a lot of your clerks probably. It extends the deadline for responding to open records requests. We were in a situation where we didn't have full staff at City Hall, so it takes a 3-day requirement and gives you 10 days during the pendency of the state of emergency to respond to open records requests. The other thing that it did was allow you to deny any on-site inspections. The open records law requires you to do on-site inspections if the requester wants to do that during the pendency of the emergency because you're wanting to limit public access to your facilities. This allows you to deny on-site inspections during the state of emergency. The Press Association and others didn't love that, but we needed a little bit of flexibility there. The main topic that we get a lot of questions about in the legal department is conducting meetings and how to conduct meetings during this state of emergency. This clarifies the law to say that you can conduct meetings by way of video teleconference without having to provide a physical location. In normal times, the open meetings law requires you, if you use video conferencing, to also establish a physical location where people can attend the meeting. This says you don't have to provide a physical location in order to conduct video meetings, and it also provides, and most of you have been using this for a while now, if you don't have access to video, you don't have the capacity in terms of technology or the availability, which a lot of our small cities and counties did not have the ability. Plus, sometimes there's demographic challenges related to the video operation. This would allow you, if it's not available, to do so by audio conference as well. In order to take advantage of these things, you have to provide a notice as if it's going to be treated as a special meeting to give specific information on how members of the public and the media can access the meeting, whether that's a link to a Zoom call, the audio conference number to dial in, or you're streaming it on a cable channel. How can the public see and hear it, see it if you're doing video? And if you're conducting a hearing that requires testimonial evidence to be presented, so you're doing a hearing on your municipal road aid funds, that has to be done using video conference. You can't use audio conference for that. So this will only last during the period of the state of emergency. It also suspends and tolls, very importantly, deadlines for responding to planning and zoning and code enforcement process. As you all know, code enforcement, there's default judgments and default rules that require dismissal of a code enforcement case. Likewise, certain zoning amendments would be automatically approved if there's failure to act. We heard from several cities that were having difficulty having their planning and zoning meetings or board of adjustment meetings, that we needed to suspend and toll those statutory deadlines during the state of emergency, is ultimately determined by the executive authority of the local government. So in most of your cases, your executive order that declared a state of emergency gives that to the mayor, regardless of your form of government. So ultimately, in most cities, the executive authority, being the mayor, would determine whether or not they wanted to continue to proceed with planning and zoning meetings via Skype or Zoom or Microsoft Teams or whatever you're using. We had a lot of cities that went ahead and assumed that they could do executive orders that permitted an extension in filing their occupational license tax from April 15th to July 15th. That was a good home rule assumption, but unfortunately, the state statutes required them to be reported that way. So we wanted to be sure everybody was in compliance, and so we got in language that did in fact affirm and permit that local governments could extend your occupational license tax filing deadlines if you wanted to do that. Brianna?
House Resolution 135 creates the Kentucky Emergency Preparedness Task Force under the Legislative Research Commission to assess Kentucky's preparedness for the statewide emergencies, and they are required to establish a plan of action for addressing components of the preparedness that need improvement. This also requires work within the healthcare industry, businesses, and an examination of state and local government responses. House Bill 271 removes the remarriage penalty for a surviving spouse of a member of the Kentucky retirement systems. Currently, if the surviving spouse remarries, KRS, because of the law, the benefit will be reduced from 75% of the member's monthly average pay to only 25%. Senate Bill 229 became an omnibus pension bill for us. The underlying bill amends the legacy pension plan statutes to permit applicable cities to expedite their closure by permitting an agreement between the beneficiaries and the local governments to purchase the annuities if there are fewer than 12 participants in the plan. If there are fewer than 6 active members from one department in the legacy plan, the Board of Trustees will be composed of the mayor, chief financial officer, 1 retired member elected by the members of a department with 6 or more members, and 1 mayoral appointed employee from a department with fewer than 6. So this is just not a mandate, but just providing an option for an annuity for cities that have the legacy pension plans. Also, we were able to, because of time, add 2 other pieces of legislation to this bill, 2 other Senate bills once this bill was in the House. So we added another bill that provides, or more language that provides, a mayor or a member of a city legislative body who is at least 62 years of age to retire from their career in a CERS position without also being required to resign from their elected position. This also provides that the member shall not accrue additional service credits or benefits for the elected position after his or her retirement date. We also added language that clarifies that for cities that are hiring SROs, that the individuals you hire, if you end up hiring an SRO, that they do not count towards the maximum cap for the number of rehired officers that can be employed without having to make the employer retirement contributions, as well as the healthcare reimbursements to the state.
House Bill 351, this is the Taylor Mill provisions. As you all know, Mayor Bell and the city of Taylor Mill fought all the way to the Court of Appeals and ultimately the Supreme Court, where discretionary review was denied. about dealing with Masonic Homes there and their requirement to pay property taxes on their leasehold interest. They took otherwise exempt property and put it and gave a leasehold interest, and they won that case. And everybody tried to amend the law since that decision came out. And so this permits cities and counties to exclude from property taxation privately owned leasehold interest in residential property that's owned by a purely public charity that are assessed by the PVA after January 1, 2021. This leaves it as an option for the local government. So if the local government still wants to assess the tax on the leasehold interest, they certainly can. If they want to do the exemption, they can do an exemption. So it's home rule. The revenue bill also permitted local governments to issue financing bonds for the construction of facilities for solar generated electricity. We still hadn't figured out why that's in there, honestly, but it's in there. It clarifies, and this is one you're going to want to take note of. This has an emergency clause on it. Keep in mind this revenue bill. It clarifies that admissions to public golf courses are taxable. The sales tax would apply. So we went from taxing it to 2019 to not taxing it. They finally settled on saying you're going to have to tax it, your green fees and your other access, unless it's a fundraising event for a 501c3 or held fundraising for a governmental entity. Otherwise, you got to collect the sales tax and remit it to the Department of Revenue. As you all know, and you're hearing a lot of press about this, we're gonna host an opportunity to talk with the Secretary of State about the primary election process in the coming days. But this is the provision that permit the governor and the Secretary of State to enter into an agreement and do joint executive orders to change the manner and place of the primary elections during a state of emergency or the general election. The state budget, House Bill 352, a couple of things in there. It provides a 1-year $11.4 billion general fund just for one fiscal year. Usually they adopt a biennial budget. Because of the situation with the coronavirus, they were not comfortable doing that. And so they just did a 1-year budget. And that's interesting concept that we haven't seen before. It's either going to force them to deal with the budget again in the short session, which requires a 2/3 majority on revenue bills, and so there's a lot of talk about a special session, not only to deal with this, but also to deal with the fact that the current fiscal year budget is anticipated to be severely cut below 5%. So there's a lot of discussion that perhaps there may be a special session prior to July 1 to deal with the current budget as well. It maintains the ARC requirements for the KERS and the teachers' retirement systems and SPRS. It did a freeze for your public health departments and other quasi-governmental agencies. Again, after the special session that we had last summer to fix it, they froze it because of the crisis. They froze their contribution rates and gave an additional $25 million, $25.4 million to local district and health departments to assist with the KERS contributions as well. It funds Operation Unite, $1.5 million for drug abuse and facilitating recovery. Appropriates $300,000 and $1.9 million for the Poison Control Center to do the hotline. It's turned into the COVID hotline. And it also permits the state to use unbudgeted restricted fund amounts to get PPE during the pendency of this 1-year budget. Several of the provisions supported the implementation of the school safety bill from the 2019 session, given the money to support employment of school resource officers and fund the Center for School Safety, and then $18.2 million that would be permitted for school safety upgrades to facilities. And one more bill related to that school safety bill, Senate Bill 8 from Senator Max Wise was introduced, and that also dealt with allowing and kind of preempted local school board ordinance to allowing school resource officers to be armed, requiring them to be armed with a firearm, regardless of the school board policy. And it also clarifies that SROs are to be assigned to each campus rather than at each school, and it maintains that requirement as resources become available in order to do that. So that's the implementation provisions of Senate Bill 8. We've shifted our focus a little bit from, is there a question? There's a question. Darren asked, with a one-year budget, will this impact the mutual road aid funding? And you've gotten revised numbers by now, I think, from the Department of Transportation that has declined or that has resulted in a decline of your municipal road aid distributions by, I think, 9%, if I'm right, Brianna, a reduced amount. Who knows what will happen next year, Darren, or if they do a special session and do the next budget year. But this year, it's the economy rather than the one-year budget that's impacting the municipal road aid allocation. So we have shifted our focus a little bit from Frankfort to Washington. As you know right now, we're trying to get revenue replacement for cities. The Congress enacted the CARES Act. Senator McConnell was the architect of that bill. It did appropriate monies to cover COVID-related expenses, and it distributed only to local units of government with a population exceeding 500,000, 500,000. The rest of it went to states in their state allocation and permitted the state to share up to 45%, less any directly allocated local governments, of the state's funds with local governments to cover their COVID-related expenses. It's very, very limited with regard to what it can be expended on. It's addressing an expenditure problem. The governor has finally released and announced last week and got specific yesterday, and on the DLG website, if you haven't seen, he guaranteed $300 million of the $645 million that we would otherwise be eligible for to be deployed right now for city and county governments. A couple of things about that CARES funding is that you have to apply through DLG. Each city is supposed to have, even though they haven't posted it on the website, we're trying to make sure they post it. It's supposed to have a block allocated amount. KCO and KLC agreed to split of the $350 million to take $250 million to go between now and for any expenses incurred between March 1st and up through October to split $250 million evenly. Lexington's came off the top, so it's $115 million split among the cities. Our portion, $115 million, would be split based on your incorporated population as a ratio to the total incorporated population in Kentucky. And that would be your block amount that your maximum amount that you would be eligible for reimbursement for if you submit these COVID-related expenses. They did agree that they would only, they wouldn't be more restrictive than the U.S. Treasury guidelines. So those guidelines are going to govern the types of expenses that you'll be able to be reimbursed for. At the end of October, it is supposed to, although those details aren't out, it's supposed to, anything not used is supposed to go back into another second round, which would be based purely on need, along with that $50 million. I think there's some hedging. There's debt. We asked the governor to commit the full 45% because of the prospects that perhaps the CARES amendment, the CARES Act would be amended in Congress to allow for revenue replacement. We're pushing in Frankfort for, we're not in Frankfort, in Washington. We're making the point that we have a whole lot less of an expenditure problem and we got more of a revenue problem because of the response to the pandemic. And so we're trying to get that allocated through the National League of Cities and other groups like that. Unfortunately, I think NLC's hitched its wagon to the HEROES Act, which has absolutely zero shot of passage through the legislative process in Washington. Has a lot of other unrelated provisions in it as well. So we've been making the point and encourage you to continue to make the point about what the government response to pandemic, the necessary governmental response to the pandemic has cost you in terms of revenue. You all know philosophically that this organization does not run to Frankfurt or Washington for handouts. We're pretty prideful on that we don't ask for a bunch of handouts. We go and ask for local authority to govern ourselves. And in this case, we can't create a tax base. The state doesn't have the money. And this is the time where Washington and the federal government needs to step up and help with revenue replacement. So whether that comes in the form of an amendment to the CARES Act, whether that comes in the form of another stimulus bill, we're pushing on our congressional delegation, including Majority Leader McConnell, to do that. One thing that we really like is that Senator McConnell is pressing on is liability protections, not only for businesses and schools and universities, but for local governments. As you all know, we run an insurance company here at the League as well. We're out on the market for reinsurance, and worldwide, the insurance industry has virus exclusions. So businesses can't get it, local governments can't get it. And just to simplify this, if there is a wave of litigation, much like is being projected by the insurance industry, that's similar to what asbestos was, then the taxpayers are directly in the line of fire here without insurance coverage. So reasonable liability protections are something that we need. And Senator McConnell's leading the way on that. So we're very supportive of him in that endeavor. So keep on members of your Congress. You don't have to tell them to sign on to the HEROES Act. They'll probably laugh at you unless you're in Congressman Yarmouth's district who already voted for it. The rest of our congressional delegation already voted against the HEROES Act, I think. But keep pushing on your senators and your representatives to give some revenue replacement to our cities to get through this. It's not about covering poor fiscal management in the past. You got to kind of correct that narrative that some of our congressmen are having. I know the congressman here in the 6th district keeps talking about that. I think Illinois may have messed that up for everybody because they came out saying, well, we'll get a bunch of money and put it into our chronically underfunded pension program. And that's set a lot of people off. We want revenue replacement that is a direct result of losses sustained because of the government's response to the pandemic. And I think if you do that message without saying sign on to this bill or do it this way, that's probably the most effective thing for the Kentucky delegation in any advocacy efforts. That's it for the federal components. I got a text from Tim Williams who asked about some cities have asked that we continue to support a request for an executive order that would change the manner in which the occupational taxes are collected and make it based on the situs of the employer rather than where the work is performed. And there's some broad disagreement on whether we ought to broach that subject or not, or make that request. Some cities have directly made the request to the governor's office. We hear from some occupational license tax administrators who think that is not a good idea because just from a practical perspective, because of your transient workers that come in from other states that do work where there's collections with that, which is probably minuscule compared to what these work from home orders are going to do. There's disagreement from a legal perspective, whether the Constitution requires it as an occupational tax to be collected based on the privilege of performing the work within the jurisdiction. So there's a lot of case law out there that the occupational tax, even though the constitutional language doesn't say it exactly that way, would require that it continue to be collected where the work is actually being performed, or where the business from a net profits or gross receipts standpoint is being collected. So, Tim, we're still kind of debating with all this disagreement. Some cities want it, some cities don't, and so we're trying to make some decisions there on how to proceed. But the league has not made any formal requests right now until we can get some both legal consensus and practical consensus among how it is. But Covington has joined you, and the city of Frankfort has joined in making that request to make that change, regardless of the potential constitutional challenges related to changing it, and the practical considerations too, because transient merchants are going to be much less than your displacement of workers as a result of the healthy at home standard. Does anybody have any questions for us? We're happy to answer any of them. I figured out how I can unmute people on this thing as well, so that way we can get other people to talk. If anybody else wants to talk, just type it in the thing or let me know, and I will unmute your phone on this webinar, and you'll be able to do that, besides Brianna, who's got her hand raised.
I would just like to add on to what you were mentioning earlier. Darren asked a question about, or made a point of, that he has not received any of the budget information. And so he, the consensus forecasting group will meet tomorrow, and we will report that information article and include it in the city limit bulletin for you all to receive late tomorrow afternoon. So that will hopefully help. Also, we just want to thank you again for all of your support. We wouldn't be able to have the success that we do if we didn't, if you weren't engaged. And so truly, it is very helpful for us, and we appreciate it.
Jim, let me see if I can unmute you here. You're unmuted. If you unmute yourself, you can talk.
All right, thank you, JD. Appreciate that. Just two things. One, just to give you guys kudos. You guys are rock stars, and I do appreciate everything you're doing for us. And I know the city of Paducah really appreciates you guys. Second thing, going back to the CARES Act and the money that's going to be allocated to the cities, you mentioned that it's from March 1st through October. So are we permitted to do multiple applications? I know the applications started today, and we were kind of looking at that thinking, how do we project future expenditures?
Well, yeah, I'll admit this. We're trying to work very, very diligently with the Department for Local Government. They didn't put a lot of specifications out there. One, the block amounts available for each city, as you and I talked about this morning via email, is not there. Our proposal that KCO and KLC presented, that they seem to endorse, even though they didn't put the information out, was that they would take multiple applications, because all those expenditures, the CARES Act permits expenditures between March 1st and December 31st. And so all of those expenditures have not yet been incurred by your government. So we envisioned, and we think they understood, that you could do multiple applications. They are supposed to create an FAQ, and Jim, I would recommend, and if you let us know too what answers you get, Billy Johnson, if you call the Department for Local Government, is the administrator who is going to be the point of contact on this, and so you can contact her. Billy Johnson, BILLIE Johnson at DLG, just to ensure that multiple applications will be taken. We need to get some of that in writing. Okay. Our proposal too was through October, that there was a first phase, and that anything not used lapsed into to be combined with the $50 million that was reserved to be more of a needs-based, regardless of city, county, or jurisdiction, type of second round with this $300 million. And they did not confirm that process either. So our understanding, it's going to be through first round through October, second round October through December. But the way it's phrased, it looks like they may be saying it's going to be one round and they've just held $50 million. But I surely don't think that's the case. But you can ask Billy, call and ask Billy, and let us know too what you hear on it.
Okay, thank you.
Anybody else? I'm on two screens here, so I can't. See everything. Well, if not, then we actually did it in an hour and a half this time, which is pretty good. I appreciate everybody attending. Brianna, I don't know whether you mentioned the fact that the update booklet is also available. If you look, it's online on the City Limit website. If you go to KLC City Limit, then you can download even more technical summaries than what was in this PowerPoint. And it's also in the legislative bulletin that come out Friday. It was in last week's bulletin where you can access the PDF or the flip book and look through that, look through the summaries and share it with your staff. Looks like there's two more people on chat. Appreciate it, David, Michael, Brianna.
Yes.
Mike's going to call you from Ashland.
Sounds good.
All right. Well, we miss you guys and hope to be able to see you in person very soon. And you call on us if you need anything at all. And have a good rest of the day and a great Memorial Day weekend. Talk to you later.
Bye.